Um, Before Candy and Racey get started, I'm sorry, this might be very difficult for me, and that's not my intention to upset other people. It's upsetting for me, but I just want to recognize a moment of silence for the people who lost their lives in Buffalo, New York, most of whom were Black, and the Taiwanese people who lost their lives at the Taiwanese church, who are mostly obviously Taiwanese. So if we can just recognize that for a minute, I would really appreciate it. Thank you, Candy. You go ahead.
Okay, thank you, Misty. And welcome everyone to this third webinar in a series hosted by the Shakopee Diversity Alliance, focused on social justice in the legal system. My name is Candy and I'm on the board of the Shakopee Diversity Alliance, also known as SDA. SDA respectfully acknowledges that this land we call Shakopee is the ancestral homeland, carefully stewarded by the Dakota people of the Great Sioux Nation and unfairly ceded in the treaties of 1837 and 1851. Sadly, as the United States of America, we have still not fully advanced as a united and liberated nation. SDA strives to be a welcoming community that is a safe place for healing and for learning together about what it means to be an ally, an accomplice, and an activist at any level that suits us as individuals and as an organization. If you are not an active partner with SDA yet, we would love for you to join us for any or all of our meetings and activities. Follow us on social media and become a financial supporter at whatever donation level is comfortable for you. We have a fundraiser now on Facebook called Growing Kind Humans, where you have the chance to bid on bundles of wonderful children's books and other children's items to learn about diversity and inclusion. Also, please save the date for Shakopee's very own Juneteenth celebration to be held on June 19th. Watch your email and social media for more details on this special gathering. You will receive a follow-up email after our conversation here tonight, and you will find our contact information there to let us know of your interest. Joining me tonight from the SDA Allyship Committee are a few of our dedicated volunteers, Heidi, Kelly, and Misty, who led our moment of silence and serves as our SDA Vice President and Chair of our Allyship Committee, will lead our discussion with our guest speaker, who will address questions identified by our board and other SDA volunteers. If you have questions throughout the discussion, please enter them at any time using the Q&A function on your screen. We will not use your name if your question is selected, and questions submitted in the Q&A will be addressed later in the hour. So please join us in welcoming our guest speaker tonight, Attorney Racey Rodne. He has been an active member of the Ramsey County Bar Association's Diversity Committee and practices law with McEllistrom, Fargione, Rorvig, and Moe. Racey has readily stepped forward as an SDA ally, and we sincerely appreciate his partnership in this webinar series, including his guidance in our early stages of planning. I will now turn the program back over to Misty to lead off our discussion with Racey.
Thanks, Racey. Thanks, Cadme. Thanks, Kelly and Heidi. It might just take me a little while to kind of like pull myself together. Racey, I just want to let you go ahead and introduce yourself, as I've introduced myself pretty much every time, so I'll let you go ahead.
Thank you, and thank you, Candy and Heidi and Kelly, and thanks for all of you that are here. This is such a great series, and like Candy said, I appreciate you guys, you all asking me to help in the early beginnings, and I'm grateful for all the work you've done in putting this series together. This E&I work is extremely helpful for continuing conversations that seem to come up every time incidents happen, And I think everyone kind of, or most people have this, that like, how could this happen again? How do these things happen again? And I think these conversations are a step forward to eliminating those thoughts and then subsequently the situations from arising. So my name is Racey Rodne. I'm a personal injury and civil rights attorney at a firm called McAllister Farshire and Warwick and Moe. And I am born and raised in Minnesota. I grew up in the north suburbs in Lexington, Minnesota, which is essentially Lino Lakes or Circle Pines, Blaine. There's a million different towns up there, and then East Bethel. And then I went to undergraduate school at Hamline University, and then law school at Mitchell Hamline in St. Paul. I now live in St. Paul with my wife, and then our office is located in Bloomington off the Terminal 2 exit. And so in my practice, I kind of lucked out, excuse me, and I work at a firm that allows me they allow me to kind of do what I'd like to do. So I get while you still get a lot of things handed to you in any kind of, job, and you have tasks and you have to accomplish, goals, they allow me to practice in a way that I get to, I guess, learn and do things that I want to do. And I guess the reason why I say that is because, I'm allowed to kind of follow these passions that I have, aside from just law. And part of that's, so I'm an active member in the Ramsey County Bar Association, which is essentially just a group of lawyers, most part of the Hannipin County Bar Association and the State Bar Association. And the Ramsey County Bar Association Diversity Committee, I was the chair of the committee, and now I'm just an active member. And those are the kinds of things that being part of those organizations that allow me to speak with other individuals in a similar conversations like this, and different seminars similar to this, and to learn and develop. And so that's why I wanted to kind of start out with my kind of upbringing. I'm Native American. I'm a member of the Kiowa tribe of Oklahoma, and my upbringing though is not. I didn't grow up in the Kiowa tribe of Oklahoma, so I grew up in the north suburbs of St. Paul. So when I grew up, I was the Native American kid, and essentially when I go to Oklahoma, I'm the white kid from Minnesota. And so it's this, often, times it's a biracial identity, not a crisis in a sense. I wouldn't describe it personally for me, but it's a challenge, or something to navigate that feels uncomfortable or awkward. And a story that I was sharing earlier, just this last week, I was speaking with this woman, and she didn't mean any harm by this, but she said, introduced herself and said she was a member of a tribe in North Dakota. And I said, oh, well, I'm a member of a tribe in the Kiowa tribe of Oklahoma. And then she said, oh, are you, enrolled? And I said, yes. And then she said, is your tribe recognized? And I said, yes. And I didn't, at the time, I just was kind of flowing with the conversation, but essentially what she was asking me is like, are you a real, tribal member? And is your tribe actually recognized by the federal government? Because if it isn't, then that might, essentially it's qualifying in a sense of, are you a real Native American or not? And if she actually asked me that question, I'd say, well, I'm in my identity wise, I have a piece of me that is Native American. At the same time, I grew up in the white suburbs of the Twin Cities. So that upbringing, I wanted to preference that of that's my background and how I grew up. And that's kind of developed why I care about certain issues, and how I practice law, and why I'm, I was excited to speak tonight, and why I'm excited to be part of the diversity committee and different things. The other thing I want to highlight is something that I've spent a lot of time on in the last 7 months, is the series that I published in it's the Barrister, so it's the Ramsey County Bar Association's publication that goes to attorneys in the Twin Cities. You don't have to be in Ramsey County to receive it. So it goes to these attorneys in Twin Cities, but essentially it's a trailblazer series. It's what I titled it, on historical figures of our past and present that have blazed trails for people of color, or minorities of any sorts in the law. So essentially it's just highlighting diverse characters of our past. And a couple interesting things I just wanted to highlight, which I just think are interesting and might be helpful for the conversation. The first African-American attorney to practice law in Minnesota was 1889. He moved here from Chicago, and his name's Frederick McGee. He's extremely fascinating. If anybody has, as a history buff of Indiana, if you research Frederick McGee, it's fascinating. He's at his time, he was as big of a civil rights leader as Booker T. Washington and W.B. Boys, and he lived off a university in St. Paul here. The first African-American judge in St. Louis County, which is the 6th most populated county in the state of Minnesota, he was just appointed last year. And it's those facts that make me like, how in the world is that possible? Like what is, and a lot of it has to, and then I relate that to my upbringing, my family, how my family moved around and how we ended up in Minnesota, and how my grandmother was born in Oklahoma and moved up here. Those are all different factors of where our families go. At the same time, those facts are really interesting. The judge in St. Louis County, if anybody wants to know, his name is Sean Pearson. So that, I guess that's one of the things I guess I wanted to share, and just how like my work in the diversity committees and such have kind of developed, and where my, I guess, interests lie. And it's not, I guess it's not just there. A few other things that we've done in the diversity committee, which is also probably just as surprising, but the Ramsey County courthouse didn't have a mother's room that was accessible to attorneys and their staff. That didn't exist. There's one for county employees, which was essentially a closet. And so then I worked to get the funding and have a mother's room opened up in the courthouse. So then anybody who visits can visit that. And so those are the kinds of things that we work on in the diversity committee. So I guess that's where I'll stop with my introduction. I'm sure I could keep rambling on. I'm sure there's probably a good joke in there where lawyers like to talk too much too. So.
I think that's perfect. And I think it's good. I know before everybody started, we were having a conversation about qualifying. So for me, that's very relatable, because I didn't grow up in a place predominantly Black. I was one of the few Black people. So there's a lot of different experiences that go into that I think people forget. So I think that that's fantastic. I also want to highlight, you don't need to qualify who you are. Like, who you are is good enough, and we appreciate you coming. Now it's the fun part, the questions, which good luck. I'm just kidding. So the first question is, what qualities and skills would attorneys working in the justice system need for the system to be more equitable? Obviously, the first Black judge elected last year is part of the problem. So for your solution.
And we've made quite a bit of progress. And I can actually pull one thing up here. And oftentimes I talk about how like these facts are extremely interesting. Bear with me one second. I should have had this pulled up here. So I just like quoting this one here. So back in Judge Diana Murphy, she was the first woman federal court judge in the state of Minnesota. When she went to law school in 1975, less than 20% of the women or law students were women. Nowadays, there's over 50%. It's a majority of law students are women that go to law school. And so I think, just in general of the progress that we've made, aside from the skills and qualities, is important, because not only, that's only 1975. If I try to do the quick math there, I might embarrass myself, but that doesn't seem too far away for me in my mind, is 1975. Just from that period to now, we've made tremendous progress. So I think that's this. If society can keep that up, if we can keep that up, that's going to be helpful in itself. Now it goes to the qualities and skills, and that's rooted in that past though at the same time. So with that past, how can I and my colleagues help to make a more equitable system? Well, I think that, so for lawyers, it's oftentimes we say we only have one real weapon, like one real action we can take, and that's to go to court. And so who are the decision makers at court? It's judges and it's juries. And so when understanding that, it's important to understand who is going to be my judge, in this case, who is going to be my jury. Well, if I have a jury up in northern Minnesota, that's a completely different jury in Hennepin, Ramsey, and Scott, Dakota County, or Anoka County, the counties around here. Those are our decision makers. And so and I guess kind of where I'm leading to is I had a presentation earlier last year where we talked about, I had a prosecutor, I was moderating, I had a prosecutor, a public defender, and a judge talk about race and how it relates to criminal proceedings. And the public defender said, well, when I have a black defendant walk into the courtroom and they see a panel of white jury members, they don't want to go through with the trial, because how are those jury members going to be able to relate to them? How are they going to be able to understand them? And now the prosecutor, who is a person of color themselves, said, I am actually going to get rid of jury members that are people of color because I know they're not going to be able to relate to them. So the question was, how do you fix that? Like, how do you end up fixing that? In that situation, we couldn't, you can't figure out an answer, because the jury system, it works at times and other times it fails, but understanding and recognizing that, we're going into the system that has big faults. So the judge, who was also a person of color, said, what are we supposed to just get rid of juries? She posed the question. Are we supposed to, we have all the actors in a criminal proceeding. We have the public defender, we have the prosecutor, we have the judge. And we all recognize what is happening here, but there's nothing that we can do to fix it, to give somebody a jury trial that's actually of their peers. And how do you end up doing that in the system? And that's where I kind of go back to my main point, is that from 1975 to 2022, we have made tremendous work in the amount of simply just women who go to law school. And it has gone up for all minorities. So it's not just, I think that's going to help in that system, as long as us attorneys are going to be able to recognize, how is this system affecting the people over there? How is the system affecting my neighbor? How is this system affecting, myself? I think a lot of it's recognizing how it's actually playing out. And that's the biggest thing. I think that at that time, the inspiration for that seminar was that, I think, second degree murder trials, according to it was 3 times, if you're a person of color, you're 3 times as likely to be charged with a murder charge than a white defendant, when in fact, the population is the exact opposite. At the time when the data was taken, the pool was 75% of people were white people, and then the 25% were people of color. So I think that's where we had that inspiration. And so how is that stat playing out? And when we have all the actors at the same time, we all recognize what we're doing. How do you fix that? And essentially the conversation we had is recognizing what we're doing and not doing it unfairly, in a sense. And I don't think there's an answer to that. I think it's just, how are you going to hold those people accountable? As an attorney, you have, a fiduciary duty to represent your client to the best possible, the best you can. So then, and to do everything in their interest. So if you're an attorney for the state, you're doing everything in their interest to put people to successfully charge people for crimes. And so if you have a defendant of color and you're picking the jury pool, that, essentially it plays out that way. You don't want somebody in the jury that's going to relate to the defendant. You want somebody that's not going to like the defendant. And so as a civil attorney, I'm thinking the same thing when I'm going into the jury, except I'm trying to find people who like my client, who are going to support me. And so that's, I guess somewhat of a long-winded answer to that question. I think if we go back to the root of its qualities and skills, I think it's recognizing your bias. One is a huge skill to have, and being self-aware of your role in the system. And I think that's tough, because I think most attorneys, you go to law school, you spend all this time and money and effort working your way to pass the bar, and then you get a job, and then you do the job. And separating the job from your impact is difficult. And I've personally seen that play out quite a few times. I think a report just got released, or a settlement just got announced in, I'd have to look up his name, but he was beat up as part of the George Floyd protests. The city of Minneapolis resulted in paying him a substantial amount of money. And the question that was just kept getting answered was, why was he actually, so what happened in the facts was, a unmarked van pulled up and a bunch of people came out with unmarked gear and started shooting the little kind of the rubber bullets at people. So this man saw these unmarked people sprinting at him, and he ended up shooting their direction. Once he realized that they were police officers, he set his gun down. The police came over and then beat him up. And then they charged him with some substantial charges. So this just got, I think it just actually got announced today. So if you want to, you can, it's probably on the newspaper, Pioneer Press or the Star Tribune. But essentially, the question that keeps getting answered is, why was he charged? And why did they pursue those charges for a year? I think it was, or 6 months, or however it might have been. This was immediately after George Floyd's death. And, so the question keeps coming up is, why are these prosecutors who understand what they're doing and understand how their job is playing out, why does it keep existing? Why does it keep going on? And I think part of that's the process playing it on with the county attorney elections. So that's my very long-winded answer to that question.
Fantastic. You actually answered 2 questions, so it was perfect. And we're competing with bath time, so I'm yelling because it's like very loud behind me. There was another case that happened too with a basketball coach, because you were talking about that, who got shoved by a police officer, and he ended up pressing charges. And they went through this whole spiel, and it ended up being the cop that actually assaulted this basketball player owner, who happened to be a Black man. So I think there's just a number of cases where that occurs. So that's not isolated, it's very widespread. Not a good lead into the next question, but I'll just go with the next question. What changes in attitude, so maybe it is a good lead in, would make transformation of the justice system more possible, and how do we foster those changes? That's a huge question. Good luck.
Thank you. It is tough, and I guess this was one of the questions that I didn't have like a specific answer to. I think it's the work that we're doing right now is a large part of it, and that's kind of what inspired me to do that kind of Trailblazer series, where I'm highlighting these diverse characters of our past and present to understand that how these people fought through these barriers and how they were able to accomplish more or just as much as anyone else. And it's that sense of equality and taking our lived experiences, and understanding others. I think that's probably the best way I can describe it. It is tough though, because some of these it's these people are just, in the criminal system are just, they just want to prosecute people, right? I mean, that's their job, right? But there can be changes in attitudes and to fix that. And there has been in the past, right? So some, and I think it's a kind of a pendulum that swings. So previously, in Ramsey County, before John Choi was in office, the prosecutor's office wasn't as hard on gun charges. And so one of his big pushes was, I'm going to fight gun crimes involving guns. I'm going to prosecute those very hard. And that became kind of a theme throughout the state of Minnesota. The problem was the law had a big gap in there where they said at the time, airsoft guns were considered a gun. So you could charge somebody with possession of a gun when they had an airsoft gun. And so then there's this mass amount of charges for airsoft guns that just didn't make any sense. So then the legislature ended up changing that. So I think those things that are developing are the attitudes that we understand, because if somebody's holding an airsoft gun, which they make nowadays, that look just like regular guns, should they be charged with felony possession of a loaded weapon? The legislature eventually changed it to say no, but at the time, prosecutors were just charging everybody they possibly could, and that wasn't working out well. They were filling up our prisons and wrongfully convicting a lot of people and putting people away that had families and different things. So when those are the kinds of things that I think the system can actually, depending on who's going to be your county prosecutor, who's your county attorney, what are their goals, and what are their values, and what are they going to push on. Some people, it's for each person, it's different, and they have a tough job. I'm not saying I could do it whatsoever. So it's a difficult position, because they have to do that criminally and civilly. So I think it's under, and again, I kind of go back to understanding how the system is actually playing out. I think that's probably one of the biggest highlights, and how do you end up fixing that, or putting steps towards that. So, and I do think that a lot of these offices have made some really impressive steps recently on educating their employees and educating the prosecutors and their staff about what their work is doing and how it's affecting their clients, and not their clients, but I guess the people in Minnesota. So, and I guess one thing I should say is, I'm a civil attorney, so the criminal side I only know so much. Just in the past year, I've started working on what's called exoneration cases, and so that's where people have been wrongfully convicted, and there's a statute passed in 2014 which allows these people to seek out remedies for being wrongfully convicted. And so that I've just recently started, and that's on the criminal side. It has some civil elements to it, but that's kind of trying to find remedies for people who have been wrongfully convicted. So that's probably the extent of my real criminal experience, other than from what I've seen as a civil attorney and working with colleagues.
I think you did good. That was a big question. What types of trainings, which is what I was going to ask, are attorneys involved in regularly to address biases? This is kind of like a multifaceted question here. So are there requirements of attorneys for bias training in your place of employment or within the system itself? So for SDA, we took IDIs to kind of see where our own biases lie and how to deal with those. So that would be an example. So for you guys, what does that look like?
Yep. So we have our continuing education requirements. I think it's every 3 years. We have to get elimination of bias credits. So many of them, I think it's 6 credits. So essentially 6 hours, which really isn't a whole lot over the course of 3 years. And don't quote me on that. I have to look up the exact requirement. But oftentimes you get those naturally, in a sense, from going to other trainings and events. And so almost anytime someone has a CLE, a continuing legal education program, if it's more than just a single hour, most people try to tie in an elimination of bias credit in there. So that's what we're required to do. Now, what we do practically is probably different than that. I'd say it depends on the attorney, their office, and what they're required from. So I think it's CLEs for civil private practice attorneys. I'm seeking CLEs that I'm interested in, and 2, there's probably a marketing component to some other ones that I'll go to. And then for me personally, 3 is I plan them. So for the Frederick McGee, who I mentioned earlier this year, I wrote a letter to the author of his biography, who lives here in St. Paul, and I couldn't find an email or a phone number for him, and I got him to speak about his research and how he wrote the biography for Frederick McGee, which is fascinating. I think you can get it at most libraries. The Minnesota Historical Society publishes that book. But so that's I guess I was kind of going to the practice. So that's how it, I guess, practically plays out. We're required of us. We have to do it every 3 years. And then you go into the specific offices. The big law firms have someone who's employed to ensure they have diversity trainings for their office, employed to specifically understand how to work with disabled folks, how to work with people who've experienced crisis in the past, how to work with people of color that they don't understand, they have a different background from. The big law firms have individuals who then plan those trainings and have them for the staff and for the attorneys. For I'd say county offices, from my experience, I know in Ramsey County, they do require trainings for their attorneys. For other offices, I think it probably depends. And I think the people you're kind of leaving through the gaps is probably kind of solo practitioners who have they're running a business and trying to practice law and do all these different things. They're probably in a bit of a tougher position, but if they do have to require, it is required, so I'm sure they're seeking them out. So then for me, there's another part of the question that I wanted to highlight, and that's, so we have a pretty awesome group of affinity bar associations, is what we call them. So it's the Hispanic National Bar Association, the Minnesota American Indian Bar Association, Minnesota Association of Black Lawyers, Minnesota Black Women Lawyers Network, Minnesota Hispanic Bar, Minnesota Lavender Bar, Minnesota Asian Pacific American Bar, and then the National Asian Pacific American Bar Association. So those are the affinity bars, and then that have specific members. And then what we do quarterly is we meet up and try to figure out what are we all doing here, and how are we doing good work? How are we making progress, and how are we serving our clients, and how are we working with our colleagues and improving ourselves? This meeting actually happened yesterday, and this is probably why all my Trailblazer series is kind of in my mind, is because they invited me to talk on publications and how affinity bars and their members can be more involved in legal publications. So that's another thing that we do, and how there are groups to help do this. And those groups put on events. Each group has a great event every year, a big event, and then they all put on these CLEs that I was talking about. And they're probably some of the more interesting and well-attended CLEs. Not everybody wants to learn about the intricacies of insurance law. More people are excited to hear about, the first Black attorney in the state of Minnesota, and then how insurance law works.
Come on, that sounds really exciting. I just think it's cool to have all the affinity groups, and the fact that they're available and for people to participate is really fascinating. You have that collaborative group of people, and then they can share that out. I just think that is huge, and it gives people a very different world perspective, like you were talking about for yourself, and it gives other people you can never understand what you don't live, right? But it gives people a glimpse into something other than what they see every single day, which I think makes the world a better place. It just does.
Misty, if I may add one more thing that I've thought of. So one program that we were working on after George Floyd, we had there's meetings upon meetings upon meetings about how we go about things. And I'd say one thing that we definitely need to work on as a profession is wellness. I think I've kind of highlighted that a lot of attorneys just are doing a job. And so as a prosecutor, I had a prosecutor friend who said, as a prosecutor, how am I supposed to go back to work after George Floyd happens? And I'm supposed to be motivated to go prosecute people and work my job after that happens. And the people I'm trying to support are these government actors. I'm supposed to support the police officers are the ones who bring me the case, and then to prosecute and bring charges. And I'm supposed to go into the office tomorrow and go support those people. And so that was a really hard thing, I think, probably for most of the profession that deals in the kind of criminal side of things, is that, how do you highlight that paired with the profession? And I think attorney wellness has been a massive challenge for a long time. I think more attorneys, have substance abuse issues than a lot of other professions. And it's been something that there's been progress has been made, but at the same time, when you have these massive events that happen in our lives, and then we're supposed to go back to work and be, what's the law? I'm going to follow that, and then pair it up with my facts, and then make an argument or whatever it might be. That's difficult. It takes out the kind of human element that we all have within us. So that's just that little highlight that the other point I wanted to kind of bring up is I think that's something that we could definitely work on in trainings. And we have trainings like that. There's a group's, I think it's Lawyers Concerned for Lawyers. And, one of the colleagues I meet with often runs that group, and it's a great group. So we have resources for those attorneys, but it's definitely something we could work on, and how law firms can work on is making sure that we're focused on, wellness to be able to do those jobs. And we recognize that it can be difficult, challenging.
I want to dive into that for like 3 seconds because I'm thinking about the video. Like there is a video of what happened to George Floyd. So we'll see if I can get through this without having my own breakdown. But how many times can you watch him die over and over and over again? Even for me to not watch it more than 2 seconds is very traumatic. So I can't imagine being an attorney and having to watch it literally on repeat, or be a juror or a judge, anybody in the room. That's not most people's normal. And I don't think it's normal for anybody to view that regularly. Or Ahmaud Arbery, who was murdered in Georgia, like just how graphic and traumatizing that can be. So I think that's really fantastic that you hit on wellness, because it is traumatic.
And I guess to echo that, I'd say like most people don't go to attorneys when everything's going well. You go to an attorney when you have a problem. So, or you need help. And on the criminal side of things, the prosecutors are continuously prosecuting people. And they have that's a tough job, because their only clients is the state of Minnesota. So what they're seeing is the worst of the worst all the time, 24/7, 365. That's their entire life. And the public defender's side of things is the same experience. But on the opposite side of it, saying, it takes the facts and the client, that their client says to get them, but at the same time, those are tough. So, it is a job at the same time. I think oftentimes, and I think that's probably why attorney wellness has been such a problem and something that we've worked on, is because people aren't coming to us to on the best day of their lives. Oftentimes they're coming on one of the worst days of their lives.
Thank you for that. Was an aside, but I really appreciate that, because that's not something that I would have thought of, but it is a big deal. What diversity, equity, inclusion initiatives are there currently or being considered by the Bar Association? I'm sure there's a lot. So
yeah. So after our meeting yesterday, a lot of it was just sharing what the groups were doing, what everyone's doing. We plan quarterly diversity summits. Is just the name of essentially a meeting where all the affinity bar groups join together. A lot of what we do, I'd say, in specific affinity bars are events to raise money to fund scholarships. I'd say that's probably like the main goal of almost all the affinity bars. And then aside from that, then it's education, educating on whatever topic somebody's inspired by. And then the reason why I phrase it that way is because all of the bar associations, that's time aside from the practice of law. We lawyers don't get paid to be part of bar associations. It's something that we want to do, and something that we care about, and something that we want to do in our spare time. And so if an event's being planned, an education event or some of the sort, if that's being planned, it's generally because somebody was passionate about a certain topic. And so that's what I'd say is I guess apart from the scholarship process, I think that oftentimes the bar associations are focused on who's inspired by something that happened in their practice or their life, and they said, I want to educate on this. When we did when I was working on the mother's room for the courthouse, we had a seminar on what are your rights as a mom in the workplace, things like that. Something that I'm currently working on. There's an artist in St. Paul that developed a virtual artwork space in a park, like a physical park. You take your cell phone. It's pretty cool. You take your cell phone, you walk down a trail, and you can see Native American artwork as you walk through the trail. The artist's name is Marlena Miles. And so I was thinking to myself, I'm like, how cool would it be to get a bunch of lawyers to go walk the park along with an education requirement? So that's something that I'm working on. So I'd say those are the day-to-day stuff. I think there are some overall initiatives that I'm probably missing out on, and I think it's most likely office driven or bar association driven. So aside from the bar association, there is a group called Twin Cities Diversity in Practice. And I have their info actually right here. I want to see, I don't know too much about them, but essentially it's a group of attorneys that focus on training for law firms. Training, sorry, I got distracted by the question. I'll come back to that. But essentially training for law firms to make sure that they have their diversity initiatives. So that's one thing. There's a couple different side groups that focus on, that specifically actually focus on the nonprofits that focus on making sure that law firms are doing what they can do. Because if you're not part of an affinity bar, and you're still, you're still in the practice and still working on things, these groups are the ones that want to make sure that they're still holding people accountable and still trying to improve and make some progress in DE&I work. So I did see, I guess, a question. Are you going back to question 3? Which one is in it? I guess I kind of answered that. I can try to kind of circle back or Misty, but you're the host, so if you want me to, okay, I can try to do a quick summary. The way that I best can answer that question is essentially, I think it needs to be self-awareness of yourself and how where your bias lies and how you practice and how you are as an attorney, and then pair that with what are the results of the judicial system. And the stat that I brought up earlier, I think it was Ramsey County, or it could have been both the counties, but it's 75% of the population was white and 25% of the population are people of color. Then why are 3 times the people of color being charged with felony murder? And that was the question being posed there. So as a prosecutor, a public defender, and a judge, the question we was asking, well, why is this happening when we all recognize what's going on, and how can we make some progress to kind of move forward? And I think that's kind of the answer to that question, is the sense is understanding what your role is and how that's affecting the result of the system. So hopefully that answers your question. If you have any specific questions, it's a tough one for me to answer. I don't have a solution necessarily, but that's the best thought I have.
I think your solution that you don't have is actually good. So that was a good answer. This is kind of more your wheelhouse, because I know you do some civil type claims. So this question 7 has a lot to do with, what is criminal versus civil? What rights are we talking about when we're talking about our civil rights? When does someone have a civil rights claim? Are the claims generally successful? What are the challenges? I know with George Floyd, his family received a huge civil claim. So maybe that would be a good example of like explaining the difference between the two.
Yeah, definitely. So George Floyd's a good one that just in recency. So they prosecuted Derek Chauvin criminally, and then the family sued the county civilly, or the police department, sorry, the city civilly. The other example that people always remember is oh shoot, this is embarrassing. What's his name? The football player, or back in the 90s. Oh shoot, this is embarrassing. But anyways, so in that case, he was the guy he was driving the Ford Bronco down the road. I forget his name, but anyways, they tried to charge him criminally, and
O.J. Simpson.
Thank you, Candy. I was like, how could I not memorize his name? O.J. Simpson, was charged criminally and was found innocent, but then the family sued him civilly, and he paid tons of money. So, I guess the biggest difference is that the state brings the charges criminally. So in order for somebody to be charged criminally, the state has to bring the charges. Generally, that lies with the county prosecutor. In the case of Derek Chauvin, the Attorney General took that case. Keith Ellison took that case on and was able to charge him criminally. The state does, in certain situations, they have, I guess, civil powers in a sense of like regulatory powers or administrative powers. So they can, there is an office that can charge somebody. I guess, essentially sue somebody from the state to a business if they were violating people's rights. There's an attorney by the name of Tina Burnside who started it's the Minnesota, I wouldn't do this awkward pause unless it was really interesting. So it's the Minnesota African American Heritage Museum, which is the first African American museum in Minnesota. She's an attorney with the EEOC, which just sues businesses civilly for violating people's rights. So the state can do that too, but generally, I'd say the criminal side of things, the easiest way to think about it is what happened in the George Floyd or the O.J. Simpson case. Somebody's charged criminally by the state, and then separate from that, they're sued civilly. So then in civil rights cases, it oftentimes what you're looking at is when did somebody violate one of my rights? And this actually goes to the Constitution and saying what rights are guaranteed to me by the Constitution. And so oftentimes it's unreasonable search and seizure, it's unreasonable force that you're looking at, and then can I make that claim against the actor? So there's state claims, those are 1983 claims. That's the general term you'll hear of. That's what they did bring that in the George Floyd civil case. You also can bring what's called so 1983 claim essentially is it allows you to sue the government for violating your civil rights is what it does. There's a statute that was passed, I think in 79 or 71, maybe even well before that, but I think it started becoming more popular in the 70s and 80s, and where it was a federal statute that said you can sue the government for violating your civil rights. So then you have to go say, okay, well, if I want to sue the government for violating civil rights, what right did they violate? And the most popular one is unnecessary force or unreasonable search and seizure. And so I guess that's kind of the general thing on this civil rights. So then you can sue the state actors under this claim of 1983. If you want to sue the federal government, it's a different name. It's called a Bivens claim. Essentially what it means, though, it's the same thing as 1983. You violated my civil rights. You can't, this is just to kind of diving into the weeds, so stop me if there's any other questions, but you can't sue a federal actor individually. You can sue a state actor individually. So in the civil case, they can specifically sue the police officer. In the federal case, you can't. You have to sue the United States. Just kind of, it doesn't make a huge difference in how it plays out legally, but that is something that plays out. The other, it's the 14th Amendment, and that's another common civil rights claim that people make. So all persons born are natural. I'm just going to read the amendment. Naturalized in the United States and subject to jurisdiction. No state shall make or enforce any law that shall abridge privileges or immunities of citizens of the United States, nor shall the state deprive any person of life, liberty, or property without due process of the law. So that's another. The 14th Amendment is a little bit broader than a reasonable search and seizure, which is the Fourth Amendment. So those are when you think back to those constitutional protected rights, that's when you have a civil rights claim. Now, moving on a little bit, so now that I dove into the weeds and probably added some confusion there, are civil rights claims successful? And I think the answer is absolutely not, generally. There's a lot of hurdles to cross when suing the government. The biggest one is they have this immunity doctrine. And so generally government actors can just do their jobs in a sense. And it seems kind of ridiculous to phrase it that way, but the best example I have is a snowplow driver knowingly running a red light, and then ended up killing somebody. This is an actual case. They're not civilly liable for anything in that case because the government has immunity. So the plow truck driver's doing his governmental job. He made this decision to push through the intersection. and there was discretionary, and he did it, and there's no civil liability at all. That's a huge doc. There's also this qualified, immunity. There's different versions of immunity, but those are massive hurdles. The other one, which dives a little bit into the law, but I think it's worth referencing, is that the right has to be established in order for somebody to deprive you of the right. And it seems ridiculous to think that what happened in George Floyd's case, or a lot of these cases that we see, that their rights weren't established at that time. But there isn't a specific case similar to George Floyd's case that I think would have said that right is established. And while that seems ridiculous to say, I think there is a chance that case could have been, if they sued that case out civilly and brought it all the way through the court system, there was a chance that case could have been dismissed legally, according to law. And so oftentimes that people come to me with different situations, and that's always a kind of a shocking fact, of saying, wait a second, that case could have been dismissed. But the law has a variety of burdens that establish. So yeah, somebody said define establish. So let me find I think I have a good example pulled up right here. I'm just trying to find, the law is frustrating. Don't misunderstand me. It's really frustrating. So I don't have the exact, I guess, case law up that I thought I had. But the best example I can think of was someone who was, I think like pulling out a vehicle and thrown to the ground and kneed a couple times. They said you have an established right not to get beat up when that happens. And then another person had a weapon on him, and the same thing happened, and said, well, you don't have an established right if you have a weapon on them. And the law has made these weird exceptions, which is really frustrating. That might be a bad example. So I should kind of go back and find the exact case law that says that. But essentially what I do is when somebody comes to me and they give me the facts, then I kind of go through, I start digging into it. What happened in your case? Let me find a similar case. Almost because I need to, because the law is so frustrating in that sense. At the same time, am I still willing to bring those cases forward that don't match up perfectly? Yes, because there is a chance, but at the same time, I have to tell my client, hey, there's a really good chance this case gets dismissed. And it might get dismissed, and then we have to talk about a potential appeal and in creating another established right, which seems to be already established. So that's the other thing that can be frustrating. I'm sorry, that's probably not an answer that really helped it out to Karen Perkins. So I do apologize. I should have been more prepared for that question.
I want to make sure I leave time for questions for the audience. But so as we're talking about, you kind of touched on it, but like George Floyd, Justine Diamond, and Dante Wright, what are some, because your specialty is more civil law, what are some of like the bigger civil claims that have come from that? Obviously, we've seen the money part as the community. Well, they got $87 million. Or for, O.J. Simpson, his ex-wife's family and her boyfriend got a great deal of money. But like, as we're going, like, what does that look like? Because all we see is like the financial part. We don't see like the process part.
Yeah, so I actually have the George Floyd complaint pulled up here, and I'm just going to show just a few pages of it. Can you see that? Okay, great. So this is count one. So this is the Fourth Amendment violations. So this is saying there's an unreasonable use of force, and this is where it's talking about specifically when you go into the state, you can actually sue the individual officers. When you're going against the federal government, you can't. You just have to sue the United States. And so then I just wanted to highlight these claims below. If my mouse is going to work. It's going to say a Monell claim. So this one's more interesting. So this says, and you can kind of read this first paragraph here. It talks about the policy. It talks about the mayor, the city council, the police chief had policymaking authority. The Monell claim was a claim that, and I can, are people reading that? Because I can pause for a little bit. I can share that with you. It is a public document, so there's no problem sharing that. So, and it goes on, I guess it goes on to essentially focus on the policies and what they have, you know, in this complaint, what they claimed was, there's a phrase they use often is where is it? Killology training, and that's a real training that they used, was killology training. And I can share that with everybody. But essentially, the focus, I want to focus on the Monell claim. So you have Fourth Amendment claim, you read 14th Amendment claims. The Monell claim essentially says you have policies, trainings, and procedures in place that discriminate against people. And I think this might be a really good way to end this. Is kind of how I've been talking about understanding how what your role as a lawyer affects the outcome. In this case, what they claimed, they said what the police are doing and what the outcome of that is discriminatory, and what it's resulting in, what it resulted in, and what it is continuing to result in is situations like this, what happened to George Floyd. And so that's the other claim that you can make as a civil rights claim, is saying you have discriminatory, not only did you violate my rights, but you also have policies in place that violate my rights and everyone else's rights. And that's one of the really good things I think that was in that case, in that complaint, because they knew, I guess, essentially and practically, they knew that case wasn't going to go all the way to a jury trial like we see in the criminal cases. They knew that case was going to be resolved early and often. So they had to make sure that their complaint it had the legal basis behind it, and in the rare circumstance that it would move forward, but at the same time, they wanted to say, this is what you're doing wrong, and walk it out paragraph by paragraph by paragraph. So I do think the Monell claim, it is a more popular claim these days. So it is something that these civil rights cases, that the claims being brought more often.
Racey, do you think that the recent human rights report on the MPD will affect civil cases?
I don't think it necessarily affect if the cases are successful or not. I think it's going to be hard. I think it's going to be tough for civil cases to be more successful. Mm-hmm. And I guess the reason I say is just the law is not on our side. I think what can be on our side is public opinion, and it can be public pressure, I think, is on our side. But for how, if they're successful, I don't think that, and the part of the problem is that if all the cases, if the city, like say the city of Minneapolis, admits everything that's in the report, they say, yep, we've done all this stuff, and you can sue us all, essentially there has to be some kind of line drawn in the sand saying either we create a fund for all these cases, or we just have to, we can't, defend them, or there has to be some kind of line drawn in the sand for that to happen, just from different situations, I guess, is my thought. I think the law is just extreme. The way it's developed with a lot of conservative courts has just been extremely frustrating and anti-plaintiff in a sense at times. And maybe I'm sure there's other attorneys that might say no, that's the way it should be. But in my work and my, I guess, bias, I try to be, as aware of that side at all. It's definitely anti-plaintiff in civil rights cases.
Now is a great time for other questions. I'll give it a few minutes. If nobody has one, then I will respect people's time and let them promptly go on. I just want to tell everyone thank you for managing my children with me as they were going to bed, because that happens a fair amount. Oh, you have a very involved question. I can read it.
Yeah, no, I have it. I think I have it here. I was gonna, yeah. From Jolie, is that the one you're referencing, Misty?
Mhm.
Great, okay. Yeah, so that's tough, in my experience. So I have taken some phone calls, about situations like that. And I guess I don't have necessarily an answer, in that specific situation. Now, I have provided, I guess, support and guidance for people who have been, abused by police in a sense, and tried to point them in the right direction of how far can I actually help them out, and then try to point them in the direction of other people, other organizations to help people out like that. And it's tough. The barriers in the law are frustrating. And so in that kind of my, in regards to helping somebody guide through the process of what happens after they just were abused by police officers, it's, and whether they have a claim, and the idea, I think, in the, it's seeking this justice and seeking accountability, and it's seeking people for taking responsibility for their actions. I think that's the common theme, that I've seen, is what people want. And oftentimes people won't do that because they think it opens the door for these big lawsuits and different things. So I think that's, but I do think that there's going to be some, and it's something that I'm currently like working. I don't know where it'll go, but trying to find a way to say, we want, sometimes an apology is worth, and accountability is worth more than whatever dollar amount there might be. If somebody's healed up fine after getting beat up, then, yep, I guess, Julie, I do agree with you on that second point. So she says, if a child is beaten up, my thought that the other child has assaulted another, that is a crime, 100%. I guess I'm talking about the police in a sense. So if we go back to your school example and getting bullied, so there are different things that I think the school can do. They can discipline children, and they can, follow the school's policy. They can report things to the police. I know there's mandatory reporters, and oftentimes there's going to be a case management team that gets assigned to the child. Now, suing a school is similar to suing the government, in the sense of there has to be some kind of, way to get past this immunity doctrine. The immunity doctrine said, and in its general forms, there's a variety of it, but the most common one is discretionary immunity. So if a government actor has discretion, and they act in that discretion, they weigh political or economic or social factors and then act upon their discretion, they have immunity. Now, if they have a school policy that says you can't do this, you can't move the lunch table over here, and then they do that, and then something happens as a result of that, you can get past immunity. Does that make sense at all? So if it's very bare bones and what's called ministerial, if it's ministerial, you can have a successful claim. Oftentimes what happened when that law developed over the last 40 or 50 years is that the schools and the government changed all their policies, and they said a teacher may do what they do, as long as it's in the best interests of X. And then the teacher then can come in and say, well, yeah, I let the kids, play in the hallway and do whatever they wanted to do because I thought it would help them become X, or Y or Z. And that could almost be good enough to escape that immunity. And sometimes it isn't. And it depends on the facts, of what actually happened in that situation. The whole other side of things on the civil claims is that the only remedy is money. That's the only remedy that civil cases have. Criminal cases, they can they, put people in jail or discipline, people, and they can require people to do certain things. In civil world, all you can get is money. And so at the end of the case, who's the decision maker is going to be a judge or a jury. And so now if something happens in a school where, something happened, what I'm thinking about is, what is a jury going to think in this case? How is a jury going to interpret the situation and get there? And then on the other side, well, I'm a year to a year and a half away from a jury if I sue the case out today. And then I'd say, I'm not ready to sue the case out today. I need more facts. I need to talk to the parents of the other kids. I need to talk to this or that person. And then I'd say, okay, well, now we're ready to sue the case out. Now we're 3 years down the road. And that's especially difficult with minors because kids, are resilient and moving and it just depends on, I guess, on the child. But that's, now I'm kind of, venting it a little bit. Candy, yes, no restorative justice in a civil case. You can negotiate that, I think. And I think in the George Floyd case, they did negotiate that as part of the settlement. I never, none of us really got to see exactly what they negotiated for in that settlement, but I think that's part of it. Is they asked for different policies to be changed and different things to happen.
The other question is, do you do tribal courts? Do you ever represent tribal cases?
I personally haven't, but I've been waiting for one to happen. I've been trying to find one that fits me oftentimes. So the tribal courts are really interesting. They don't have the same standards that that the state courts have. They're sovereign nations, and so they don't have, the Constitution isn't, unless the tribe makes it part of their law, isn't part of their law. So the common theme that I've, at least from learning, is fairness in tribal courts. They'll say what's fair in the situation and then make a decision based on that. Minnesota is really interesting because certain people can get prosecuted. Tribal members can get prosecuted by the state, even though the tribal member is acting on a reservation, for example. Other tribes, they can't. And the Red Lake tribe, for example, the state has zero power up there whatsoever. In Shakopee, in the Mdewakanton Sioux tribe, that one is a little bit different. I think it is where the state does have some powers, but generally, I think what the tribes are doing are family issues and business issues, and they do have some criminal situations. There's not a lot of civil things that go on there outside of business law, I don't think. So, but I've been waiting. I've been actually I'm waiting to get admitted into the Mille Lacs court. So maybe hopefully that happens this year. My tribe, just as a off topic, we just passed our constitution 4 years ago. We've been a very disorganized tribe over so many years. There used to be a council. That was the popular way for tribes to be established, where you'd have a council of leaders, and then they just decide the tribe's affairs. And then there's this big push for tribes to model the American government, have a constitution, a court, a legislature, and an executive branch. And so we just passed that, I think, 4 to 5 years ago. The court still isn't established in my tribe. If they have a room that's going to be the courtroom, and that's about it.
I did not know that. That's actually quite interesting. I have some very distant experience with the law, and I grew up in South Dakota, so Flandreau is a reservation, and they used Minnehaha County for a lot of their things because they didn't have the same kind of space. So I just think that was very interesting. I do have one question about a lot of the things that happened in the news that we saw in Prior Lake for like the race-related things. So basically, based on what you're saying, is the parents of those incidents couldn't sue the school district for not, addressing the issue. Is that kind of what you're saying?
I guess I don't want to say that specifically, but I think they'd have a few hurdles to get over. And now, so I don't want to say that they just can't do it at all, but I do think that it's going to be, you could probably make a civil rights claim in those cases saying that, I'm just walking it through my mind. You could say that, they didn't guarantee those, when a school takes responsibility of a child, they're also, taking on responsibility and ensuring that they're safe. And you have to protect your rights, as if you're voluntarily taking over the custody of somebody, you have to make sure that you're keeping the rights safe. And then you could say that they failed to do that. There could be a claim there. I don't know of a successful one, that maybe that's the better way to put it. I haven't seen any kind of case that's like that that's been successful in Minnesota.
I think that that's very sad, but probably very true. So thank you for being honest. I also want to thank everybody for joining us, and thank you for their time. Thank you, Heidi, Kelly, Candy. For sure, Candy, you do a great job. And then Racey, thank you very much. And thank you for allowing us to have that minute of silence. I think there's a lot going on in the world, and there's been a lot of mass shootings in the last just few days. So thank you for allowing that space to occur.
Yep. Thank you. And if I may just say thank you very much. The last time I met with you all, I was motivated and just happy about, these groups that are doing DEI work, that it's invaluable. Like I said, I think the solution to, that we came out of that meeting with, in the presentation with the judge, the prosecutor, and public defendant, was essentially having conversations and continuing to recognize how our actions are contributing or preventing these results. And so things like this are extremely valuable. So if I didn't answer any questions, please feel free to reach out to me, and I'm very grateful for being here. Thank you. Thank you all.
Thank you so much, Racey.
Thank you.
Good night, everyone.
Thank you. Good night, everyone.